الجامعة الإفتراضية السورية. مقرر مقدمة إلى علم القانون والأنظمة القانونية للدكتور عماد الدين محمد. تقدمة مبادرة ضوء بصوت ريم سروجي. Chapter 1. Definition of Law. What is law? Law is a set of rules and principles that govern a society. It consists of both rights and duties. There are rules that govern on how people should behave, and there are also remedies for when something happens as a result of people not following those rules. The laws of any culture tell people three things: what they can do, their rights, what they must do, their duties, and what they may not do, illegal actions. In addition, there are usually specific types of punishment for those who break the law. Law should promote justice and correct conduct in a society, and it should provide rules and a process to settle any disputes. Law is not stagnant, but it is subject to change. Law can and does evolve and change in response to changing societal needs and customs. The law is living, growing, dynamic, and adapting. What prevents crime? All societies have laws, but they do not all have the same idea of justice. They do not all have the same view of what is right and wrong, and how wrong should be punished. Most Western cultures have the view that punishing criminals will prevent them from committing further crimes. This view also includes the idea that the fear of punishment will act as a deterrent to prevent others from committing similar crimes. However, many non-Western cultures do not view punishment as a deterrent to prevent crime. Rather, importance is placed on restoring the balance in the situation. Example: a thief may be ordered to return the item he has stolen instead of, as in Western societies, spending time in prison. Sometimes the victim may be paid compensation, but they are still without the item that were stolen from them, unless the police manage to recover them. Kinds of law. Another difference in the concept of justice lies in the various ideas of societies of what laws actually are. In Western societies, people consider laws quite different from customs. There is also a great difference between sins, breaking religious laws, and crimes, breaking laws of the government. In many non-Western cultures, however, there is little separation of customs, laws, and religious beliefs. In other cultures, these three may be quite separate from one another, but still very much different from those in Western societies. For these reasons, an action may be considered a crime in one country, but be socially acceptable in another country. Example: a thief is viewed as a criminal in much of the world. However, in a small village where there is a communal living and the sharing of objects, the word thief may have little meaning. In fact, in some tribal societies, there isn't such concept or word for a thief because the people do not need to steal what they all own. If a person does take something without asking or informing others, then it may be considered as thoughtless or impolite. Civil law and society. Most countries have two kinds of law: criminal and civil law. People who have been accused of acts such as murder or theft are heard in the criminal justice system, while civil justice deals with people who are believed to have violated other people's rights. The use of the civil system reflects the values of the society in which it exists. In the United States, where personal individual justice is considered very important, civil law has evolved into a big business which can generate a lot of profit for lawyers and law firms. It has been estimated that there are approximately over 700,000 lawyers in the United States, and many of them work with civil suits. This means that they work of people who want to sue, bring legal action against others. If a person falls over a torn rug in a hotel and breaks his or her arm, he or she might decide to sue the hotel owner so that they will pay his or her medical costs. However, in Japan, by contrast, there is very little use of the civil justice system. Lawsuits are not very popular in Japan because social harmony peaceful agreement is even more important than individual rights, and many people would rather reach agreements outside courts. The judgment of disputes. In most cultures, when people cannot reach agreement on their own, a judge is usually consulted to make a decision. In North America, a case might be heard in a court of law before a judge chosen by the government and perhaps a group of citizens in a jury. In some tribal societies, however, a man or a woman who is thought to have special supernatural power might be chosen by the people to judge disputes. Social justice. In societies where courts and judges do not exist, self-help may be necessary and socially acceptable in disputes. Example: if a cow has been stolen, the owner's friend and relatives may work together and help get the animal back. In small villages, everyone, in a sense, may take on the role of a judge. In such societies, where the neighbors are also friends, members of their families or co-workers, the opinions of the villagers are very important. Social disapproval of an individual's activities can serve both as a powerful punishment for crime as well as being a strong deterrent to crime. Of course, one could argue that this proves that law is inconsistent and impossible to apply across all societies, and also asks the question of where and how conscience play a part in preventing crime. Major legal systems. Throughout history, many legal systems have prevailed either successfully or side by side. Despite their differences, the main legal systems of the world can be grouped into four main systems: Roman law, civil law, Islamic law, Sharia, and common law. The Roman law. Roman law in modern times is used to understand all the laws which predominated among the Romans without regard to the time of their origin, including the collections of Justinian. In Italy, Roman law was exclusively the law of the citizens of Rome, Jews civil. However, the gradual extension of the power of that city made its people the masters of many people. The Romans did not abolish the national laws of the people whom they conquered, but the privilege of Roman citizenship was often given to members of the vanquished peoples, resulting in the expansion and widening of Roman law. Jus gentium. Roman law underwent great change as a consequence of the contact of the Romans with foreign people. New elements were introduced into it from outside and under the guidance of judges who administrated it and the jurists who explained it. Roman law became suitable for the regulation of the interests of the many people who were included in the Roman Empire. The ultimate extension of Roman citizenship to all subjects of the Roman Empire made Roman law in keeping with the same boundaries of the Roman Empire. So, a system of law which had originally been confined to an unknown city graduated to becoming in its modified form the law of the then civilized world. Roman Germanic system. French law belongs to the Roman Germanic family. This group includes those countries in which legal science has developed from Roman law. This rule of law is a rule of conduct which is closely linked to ideas of justice and morality. Determining and formulating these rules depends upon legal scholars who are involved in the task of stating the doctrine, la doctrine, on an aspect of the law. These legal scholars are not so interested in the actual administration and practical application of the law, due to such matters being the responsibility of the courts, who formulate la jurisprudence. Law originally developed for historical reasons as an essentially pre-Debate law, which was a means of regulating the private relationships between individual citizens as time passed. Other branches of law were developed. but less perfectly according to the principles of le droit civil, which is still the main branch of legal science. The Roman Germanic family of laws originated in Europe. It was formed by the efforts of the European universities which formed the 12th century and on the basis of the completion of the Emperor Justinian. Evolved and developed a juridical science which was common to all and was adapted to the conditions of the modern world. The term Romano-Germanic has been chosen to show respect to the joint effort to the universities of both Latin and Germanic countries. Colonization of the European nation enabled the Romano-Germanic family to conquer vast territories where the laws either belonged to or related to his family. The phenomenon of voluntary reception has produced the same result in other countries which were colonized, but where the needs of modernization or the desire to westernize have led to the development of European ideas. Outside of Europe, its place of origin, these laws, although belonging to the Romano-Germanic family, have their own characteristics which make it necessary to place them in distinct groups. Many of these countries absorbed European laws, even though they already had their own civilizations and cultural and social lifestyles based on their own indigenous institutions, all of which predate the arrival of European laws. Finally, with respect of the countries of Africa and America, it will also be necessary to ask whether their geographical conditions and population distribution, which have contributed to creating conditions completely different from those in Europe, have not led to the development of laws substantially different from those in European. Civil law system. Civil law, or the Latin law system, includes the countries whose laws are based on the Roman law. Civil law is the legal system which differs from the common law of England and the canon law. The civil law system is based on codes rather than custom and precedents. This system is characterized by the complication of legal principles into scientifically arranged codes which are promulgated by the legislative authority. In this system, the courts have a limited role in applying the law as contained in these codes whenever they are presented with a case by two opposing parties. The laws of most Western European countries are based on the Latin law system. This also includes Latin America, most African countries, most of the Arab world, Japan, Thailand, and Turkey. France is considered to be the leading country of the Latin law system due to its advanced development in the regard. Though Syria is influenced by Islamic law, specifically in matters of personal status, it belongs to the Latin law system. Countries which have adopted or used the Latin law system are characterized by the fact that their first source of law is the legislation, which is enacted law. The Islamic law, Sharia. Islamic law is one aspect of the religions of Islam. Islam includes a theology which establishes dogma and states what a Muslim must believe. It also includes the Shar or Sharia, which has established the rule of behavior of Muslim. The Shar or Sharia means the way to follow. This is known as Muslim law, which is a focus on the ideology of what the obligations are of a Muslim rather than on the rights of the Muslim may have. The sanction for this obligation in the state of sin into which the Muslim who neglects his or her obligations will fall into. For this reason, Muslim law does not always apply interest to the civil sanction which is attached to the violation of its prescribed law. Islamic is basically a religious of the law. The science of Muslim law is called fiqh. Fiqh is divided into two major parts. One is the roots, which explain by what methodology and what based of the body of solution make up the shar or divine law, were established. The other is Doctrine of the Branches, Furud, which contains the systematic elaboration of basic solutions of Muslim law. Sources of Islamic law. There are 4 sources of Muslim law: the Quran, the Sunnah, the Ijma', and the Qiyas. The Quran is the sacred or holy book of Islam, and this is the main source of Muslim law. However, the Quran is not a book of fiqh or code of Muslim law. The Sunnah contains the way of life and conduct of the Prophet Muhammad. This serves as a guide for Muslims. It is made up of the collected traditions called the Hadith of the acts and statements of the Prophet Muhammad, which has been passed down through the uninterrupted chain of intermediaries in the 9th century AD. 2 great scholars of Islam, Al-Bukhari and Muslim, undertook detailed research and verification of the traditions in order to establish the authentic hadith of the Prophet Muhammad. The Ijma' is the 3rd source of Muslim law, means the unanimous agreement of legal scholars. Ijma' has allowed for the recognition of the authority of solutions which were not derived directly from the Quran or the Sunnah. Within the Muslim community, different schools, known as madhab, are admitted that are most commonly called rights, and each form a particular interpretation of Muslim law. These rites were instituted in the 2nd century of Hijrah. There are 4 orthodox rites: the Hanafi rite, the Maliki rite, the Shafi'i rite, and the Hanbali rite. The Hanafi rite has the largest number of followers. The Quran and the Sunnah are fundamental sources of the rules of Sharia, are based on them, while the Ijma' is an exceptional practical significance. Qiyas in Islamic law, the deduction of legal prescription from the Quran or Sunnah by analogic reason. Qiyas provided classical Muslim jurists with a method of deducing laws on matters which were not explicitly covered by the Quran or Sunnah, without replaying or unsystematic opinion, ra'i or hawa. According to this method, the ruling of the Quran or Sunnah may be extended to a new problem, provided that the precedent's asl and the new problem far' share the same operative or effective cause, illah. The 4 main Sunni schools of law, madhahib, consider it one of the 4 main sources of law. Common law. Every legal system essentially corresponds to practical demand. The English common law is practically responsive to the pressure of daily life throughout its lack of any broad, rigid framework. In England, the law of the land is called common law. Common law is law which has been developed by the judiciary and is called judge-made law. It is formulated as cases are decided and the legal opinions are issued in these cases. Common law is based on court decision as opposed to a formal set of written laws such as statutes. It should be noted that parts of the law in common law countries are embodied in written statutes such as the concerning negotiable instruments. The origin of law in the United States of America is English common law. The appellate courts in the USA have established common law throughout their published written decision of cases decided in their jurisdiction. In the USA, English common law was adopted by the founding fathers. The development of modern laws was based on written constitutions, statutes, and judicial decisions. When the colonies in America were first settled before the Revolutionary War, many of the people came from England and they brought with them the legal philosophies and structure that existed in England at that time. The settlers at that time maintained the basic tenets of England of English law, but they also adopted rules that suited their society at that time. They chose to discard those rules that they felt infringed on their desire to free themselves from a burdensome taxation system and an English military, so that they could enable themselves to become self-sufficient from their home countries. So in this sense, we can see that the law was beginning to evolve, change and adapt according to the changing in the society and culture at that time. In summary, English common law is judicial or case law, and also known as judge-made law, which are derived from the opinions of the courts. Therefore, the published appellate court opinion are common law. In the common law world of today, there are certain civil law enclaves, the province of Quebec in Canada and the state of Louisiana in the United States. The legal system of the Scandinavian countries carries the features of both the common and civil legal systems without being derived from either. It is a compromise between the two legal systems. The laws of the Scandinavian countries are not usually compiled in systematic codes, but they are presented in the form of wide coverage. نهاية التسجيل. هذا التسجيل يغطي من الصفحة 1 إلى الصفحة 13.